else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm
Okay now. Young Thug's lawyer was taken into police custody during Young Thug's trial. During his trial. I mean, the YSL trial just keeps seeing lawyer drama. From one of the defense lawyers being arrested on gang-related charges to a different defense attorney being arrested for going through a security checkpoint with prescription medication. And now this. Attorney Brian Steele was held in contempt of court and taken into custody earlier this week. Let's talk about it. If most of you have forgotten about the Young Thug YSL trial, that is totally okay. A lot of us have forgotten about it. It's literally been the longest trial in Georgia history, with 10 months of jury selection and 8 months of trial and counting. Can I just say, 10 months of jury selection is so crazy. In most trials, jury selection takes less than 1 day. It could go crazy and take 3 days. It can't take a month. It can't take 3 months, and it cannot take 10 years. That's wild. 2 years ago, the Fulton County DA charged Young Thug and 27 others with ties to the Young Slime Life gang, alleging that they took part in robberies, retaliatory shootings, and regular shootings called homicides. These charges are not central to our story today, however, but one witness is, a guy named Kenneth Copeland. Kenneth is a YSL associate who was granted immunity in exchange for testimony on behalf of the state of Georgia against Young Thug. But once he took the stand, Copeland refused to answer questions, invoking his Fifth Amendment rights. This led the judge to hold Copeland in contempt of the court, and he was taken into custody. Now, over the weekend, sitting behind bars, Copeland changed his mind and decided to cooperate with prosecutors. That often happens. However, it seems that Young Thug's defense attorney, Brian Steele, feels that there's more to this story. Let's watch.
Oh, go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation.
Okay, so what the judge is saying right now is, and I might have paused it like 3 seconds too early. The judge is saying, you're accusing me of having an ex parte conversation. Ex parte is Latin. It means out of the presence of another party. So normally, in normal everyday situations, a judge is not going to talk about a case with one party without the presence of the other party. Definitely not going to take evidence from a witness or a potential witness outside the presence of the other party. It's the very core of the adversarial system, which is that you get to be in the room when your opponent is presenting anything, whether it's argument or facts or whatever, to the judge. What the lawyer is saying right now is that, and he's not like accusing the judge of breaking the law. He is accusing the judge of breaking the law. Like he's accusing the judge of having a very, very unethical meeting. I'm going to roll it back 3 seconds, and then we're going to listen to what the judge says.
I'm disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too.
There are situations in which it is legal for a judge to have ex parte communication in cases, but it's very real that most of the time it is not okay. So we're going to listen a little bit more and hear this. But the judge, his immediate response was like, not to deny that this happened, but who told you about this?
And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016.
He's just citing a case to him.
Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told.
Okay, so the judge is saying whatever it is that we were talking about procedurally, we're fine. We're allowed to have this meeting. Now, I don't know. We'd need to really drill down about that. But ex parte communications are very disfavored. They do happen, and oftentimes they are legal, but in very narrow circumstances. So the judge is not denying that it happened. So I think based on what we've seen, we can say, yes, this definitely happened.
Was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm
okay now. You know when you watch a courtroom scene in TV, movies, whatever, the lawyer will ask a witness question, and then they switch, and a different lawyer asks questions. In real life, oftentimes, not usually when there's a jury, the judges themselves will question the witnesses, okay? Because the judges want to know answers that the lawyers haven't quite touched on. The witness has to answer. Now, there's an exception to that, which is if the lawyer objects to the judge's question, which seems a little weird because it's the judge who's asked the question, and you're like, oh, judge, I object to you asking that. I've actually done that before and had judges say, oh, you know what? You're right. I either asked this the wrong way or I shouldn't have asked this question. But normally, they hear your objection and they're like, no, that was my question. Oh, objection overruled. Now, you have preserved your objection for appeal, so that's fine. But keep in mind that Mr. Steele right here, he's not a witness. He is an officer of the court. The judge is asking him a question. He is saying, I'm not going to answer your question. Oh, man. Now, there are very, very, very few exceptions to a lawyer saying that he is not going to answer the question of a court. There are some exceptions. Attorney-client privilege is a real thing, and a lawyer can stand on that and say, no, I'm not going to answer. You're asking me to tell you something that is on the other side of privilege. This lawyer, Steele, he's not representing anyone who was in this meeting, and I don't think anyone in that meeting could even, ethically ask him for legal advice. I'm telling you, he's on thin ice right now. Let's see what happens.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me,
Copeland.
tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
They had a court reporter at this hearing. The judge has made it clear. This hearing happened outside the presence of Young Thug and his lawyer, Mr. Steele, and they made a record of it, meaning that the court reporter took down everything that was said. So this thing definitely happened. There is an issue as to whether or not Steele has the right to be present during the communications between the judge and a witness if those communications do not go to the substance of the witness's testimony, which I know this is the direction that the judge is going to take it. But right now, the only thing the judge cares about is who is the rat? Who told you what happened? He's not even trying to get to, were you told correctly? He wants to know, who's the source? The lady in green right above my head right now, she's the court reporter. She was there. I mean, you can have court reporters rotate in and out on trials, but the court reporter was there. The judge was there. There weren't too many people there. Now, the reality is that Copeland could have had a guest at the jail that weekend. He could have told a friend. The friend could have told someone who gets it back to Young Thug's lawyers. But nevertheless, the judge wants to know where this information came from. You know, when the lawyer was saying, I have a problem, he was saying, I have a problem with you, Judge. And the judge was like, I don't want to hear about your problems. He was actually trying to fight with the judge.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for.
Holy cow, dude! How are you going to stand there and tell the judge that he said something illegal when you weren't there to hear it? This is wild. This is wild. So what's happening here is that Copeland, he decided he wasn't going to rat on Young Thug. Then apparently they have this secret meeting and they put pressure on him to go back to where he is going to rat on him. And then this lawyer finds out about it, and he thinks that the pressure they applied to him, namely telling him that they could keep him in jail for the duration of the trial, is an illegal thing to say to him. Whether that's true or not, I don't know. I doubt it's true. Typically, if someone is in contempt for direct contempt, the longest you can keep them in jail is 90 days. That's the longest. Of course, you can always bring them out of jail, have them agree again that they're going to act contemptuously to the court, and then keep on keeping them in. But like, this is America. We try not to do this. But man, the judge is really, really wanting to know who told him. Okay.
I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there?
Why, sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes.
I mean, Mr. Steele needs to get a lawyer right here, because the judge has asked him a question. He's directed him to answer the question. Unless Steele has a really, really solid legal argument as to why he's not required to reveal the source of his information, then he's just in contempt of court. Copeland had an immunity deal on the table. If he testifies and it's truthful and he checks all the boxes for his immunity deal, he doesn't do time, or he does only whatever time he's supposed to do under the immunity deal. That thing can be scrapped and he can just become a regular defendant again if he doesn't keep his end of the bargain that he made with prosecutors.
If you don't tell me who it is, I'm gonna put you. I'm gonna put you in contempt because that is not attorney-client privilege.
Attorney work product privilege.
Okay, now that's a little bit different. When he says attorney-client privilege, he's saying, Young Thug told me. Of course, once he tells him that Young Thug told him, then of course he knows where he got it from. Now he's saying work product privilege. This is a narrower privilege, and what it does is it prevents attorneys from having to tell their opponents, generally speaking, how they found stuff out or what they plan to do with information that they have. It's basically like, you know, the 11 herbs and spices that KFC has? That's their work product. They own it. This is like the lawyer's version of the KFC spicing. You cannot use work product, in my opinion. Let me think about this. I just don't think that you can use the work product privilege to tell a judge you're not going to tell him the answer to a question that he's asked. I think you probably have a right to do it outside the presence of your opponent, AKA the state of Georgia. However, he's not asked for that. I mean, the judge could also say, hey, look, that's fine, work product. You're going to tell me outside the presence of the prosecutor. But just like saying, I'm not going to tell you because I figured it out on my own. Yeah, I don't like this. You could end up in jail this way.
I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, you know, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements.
The judge is trying to give him enough room to turn around and get off of this dead-end road. He doesn't want, he's like, I'm not going to use the 5 minutes to change our mind. You want to hold me in contempt? I'm in contempt right now. The judge, good on him. He's going to go to his office. He's going to think about this, actually, which is smart. But I think we all know how this ends.
That he admitted to killing Donovan Thomas and was, don't take my notes. No.
After that 5-minute recess, Steele continued to refuse to divulge his sources and was taken into custody. He was allowed back in after an hour and given until the end of the day to reveal his source, which he continued to refuse to do. This led to an order from the judge for Steele to be held in the Fulton County Jail for no more than 20 days to be served on the weekends. Now, this is fascinating to me. You have to understand how frustrated the judge is, okay? Because he can't have the trial without Steele being there. And so he doesn't want to stop the trial, which he really can't stop it. It's too complicated. There's too many moving parts. Williams, Young Thug, he has a right to have his lawyer there. This is so completely crazy. So he basically is saying, you're going to spend the next 10 weekends in jail. I've seen this for unpaid child support. I've seen this for unpaid fines where they say, I don't want you to lose your job, so keep on doing your work, but you got to serve your time in the county jail on the weekends. 20 days is nowhere close to what he could order him to serve because, as I've told you before, he can charge him with up to 90 days for in-person contempt. My goodness, he could lose his law license if he doesn't figure out a way to get this straightened out. And on top of all that, this is so crazy. When he's not in jail, he's in front of the same judge that has told him that he has to go to jail. So this has become an awkward workplace for both of them. But like, how many people were in the room? The judge has to have a short list of people who might have ratted out the information that was supposedly ex parte and not leaving the four walls of the judge's office. But the big picture is that Steele is convinced by something that someone told him, because he wasn't there. He's convinced that someone made an illegal threat against Copeland, telling him he could be held in jail for longer than he could, in fact, be held in jail, according to lawyer Steele. I'm not sure that that's true. I'm not sure that he could hold him in jail at all, since really his punishment would be that his immunity deal is off the table. Well, then actually he could be incarcerated. So probably it's not unfair to say that he could be in jail for the length of the trial and also whatever term he gets convicted to, if at all, from a sentence relating to the fact that his immunity deal is off the table. This is a mess Holy cow. I mean, listen, I've yelled at a judge only one time, and it actually went surprisingly well. I cannot imagine how awkward it would be to have to go to court 5 days a week in front of a judge, and at the end of the day on Friday, it's like, okay, everybody have a good weekend. See you Monday. And then this one guy's like, well, I gotta cuff me. I gotta go to jail now. Bye. So listen, this is not a winning strategy for Steele. It might be cool for him to like show his client that he's, such a tough, hard-nosed, fighting lawyer, that he stands up to the judge, but it doesn't really actually work. He should file some sort of interlocutory appeal where you say, hey, let's pause what we're doing here. Let me take this up to a higher court and let's see who's right. In the interim, though, he actually is in contempt. Like the judge has told him to answer, and he kind of has to do it. Now, if the judge has the possibility to present this issue to another judge for a ruling, maybe he should do that. I don't know what the structure inside of the Fulton County Courthouse is like, but this is a situation that's not going to immediately resolve itself. But that's just one lawyer's thoughts on another lawyer's arrest. What YouTube really wants to know is not what do I think, but what do you think? So what I need you to do right now, and don't tell me it's work product privilege and you're not going to tell me your pro se opinion on Brian Steele's arrest, because I want it down below in the comments. Should he have been held in contempt? Should the judge offer the transcript of the meeting to Steele to prove that nothing illegal happened? Let me know what you think in the comments. And while you're down there, hit that subscribe button, or else, I might hold you in contempt. Going through a security checkpoint with a prescription outside of the president. Bye.